SJC-11652, Commonwealth versus Moore.
Mr. Silverman, do you have everything?
Almost.
Okay.
Almost.
We're waiting till you get beyond almost to absolutely.
Thank you for your patience. Good morning, Your Honors. My name is Attorney Russell Sobelman, and I'm representing Anthony Moore. So if it pleases the court, I'd like to start by discussing the lost, destroyed booking video. This booking video was exculpatory evidence. The T-shirt was not stained, defendant had a chipped or broken tooth, and the police officers were not wearing gloves. This booking video was extremely important evidence to share with the jury and should have been given to the defense, especially considering it was requested. If you look at the appendix, RA33, there was a motion for discovery. Very importantly, SA005, there was a receipt for the discovery regarding Mr. Moore in the booking area. However, the prosecutor/police gave the defense the wrong booking video.
Yeah, so you say there was no blood stain on the T-shirt, but there was a blood stain on the T-shirt that was tested, correct?
Well, that's one claim from the Jessica Pusik. Two police officers
I'm sorry, Jessica Pusik is whom?
She was the forensic for the state police.
Right, and
investigator.
it was
she
the
claims-
blood, whose blood was it? It was the blood of the victim?
Yes, and she claims there was stains and blood on the T-shirt of Mr. Moore, the white T-shirt, and they were about 1/4 of an inch. However, two police officers testified, and Tullio and Pogorski, they both testified they didn't see any blood on the T-shirt, none.
Isn't it common for chemists to either see or find occult blood? I mean, we have a chemist who takes a T-shirt, puts it on a lab bench, and examines it, versus a police officer who arrests someone, and then we have blurry booking videos. I mean, wouldn't we expect a chemist to see something that a police officer may not see in a booking area or on cursory
Well,
review?
anything's possible.
Well, the burden for you to show is that that was exculpatory.
Yes, and I'm going to do that because the chemist claims that these stains or red stains were 1/4 of an inch. You have two experienced police officers who testified in two different hearings, a motion to suppress/dismiss and a trial. We're experienced, we write police reports. If we ever saw, we look for these things. If we ever saw them, I would include it in the police report. They both said they didn't observe it. So
And where on the T-shirt were the stains?
they describe it in the.
I'm sorry.
But the
chemist-
bottom part, not the bottom part of the T-shirt.
At the bottom hem or whatever. it's
Yes,
called.
but the T-shirt was out, I believe. But
So
yeah, it was
waist-
on the T-shirt.
Waist high.
Yes. There were a couple. I think there was one on the sleeve too. But basically, they were.
So what's your, I'm trying to figure out, your claim is that the police planted that on the shirt so that the forensic examiner would find it? They planted the blood? I'm trying to think what you're saying happened.
I don't know how, if there was ever any blood on the T-shirt. If it got there, it either got there by the police officers legitimately not seeing it, the forensic expert for the state police telling the truth, and it was some type of transfer.
You think the police brought it from the crime scene to the van? That was what you wrote in your brief, right?
Can you say that
the
again?
police brought the blood
Yeah,
from the crime scene to the van?
correct. That's one argument.
That's your
a
argument.
possibility. That's a possibility. But the sad part is, if the video was there, the jury could observe it, and they would decide, it would be a tiebreaker for the jury. Who's telling the truth? The two police officers that it wasn't there, or the forensic person from the state police?
But if you're arguing that the police went to the crime scene, saw the victim, and either intentionally or unwittingly transferred blood on the van, he's in the booking area after the van. That's where he's arrested.
He's arrested in the van,
Right, but he's obviously booked after he's arrested.
of course.
Of course, right? So what you're saying is that if the video showed an absence of blood, the police then took his T-shirt and planted the blood on it,
That's a possibility.
which is different from transferring it from the crime scene to the arrest at the van.
Right,
So
I
you have
agree.
two different conspiracy theories going on at the same time.
Right, there's two ways the blood could have gotten on the shirt. One is a transfer, and I should say the transfer could be A or B. One is it was transferred intentionally, or one is the police officers just missed it, accidentally.
The booking video would have shown B, the more insidious planting of the blood.
I think the video would have shown no blood stains.
Right, which
Or no
would-
stains.
Okay.
And then the jury could decide who's telling the truth. Because if they don't see any stains, the rest of Jessica Prusak's testimony, there's credibility issues. So that booking video is very, very important.
If I can go back to Justice Gaziano's questions with regard to the arrest, which officers were present for the arrest of Mr. Moore?
Trulio and Podgorski.
I'm sorry, Gerulio?
Yes, and Podgorski.
Okay,
Podgurski.
had either of them responded to the scene of the crime?
I believe they were at the scene. They then go from the scene.
Okay, when you say the scene, do we
At the
do we have
home.
any evidence as to whether or not they were in a position to have had the blood of the victim transferred to them on their hands or anything else?
I don't know. I can't remember
So
that.
there's no evidence that they were there and that they arguably were inside the...
Well, they were at the scene interviewing witnesses.
Well, didn't your brief say that the two police officers who transported the defendant to the police station were also at the scene?
Yes.
Okay.
Yes,
I
they
think
were
that's
at the
what
scene, and they were
chief was
interviewing
getting at.
witnesses.
But being at the scene is a little bit broader than being inside the apartment where
I
you
can't-
actually may be in contact with the blood.
Right. I can't recall if they were actually in the basement where the shooting took place.
There's no evidence that any police officer tried to render aid to the victim or
No.
came in direct contact with the victim and then touched your client.
No, I would agree with that. Absolutely, no.
Ms. Sobman,
Yes, Judge.
isn't your argument really not that, well, sure, you should have gotten the booking video for a number of reasons, including the ones that you've listed, but the video was lost, so we're dealing with a spoliation issue and what the remedy is. But I think, if I understand it, even though you don't come right out and say it, your real argument is that there's all these allegations of police wrongdoing going on in this case that you've listed. I won't go through all of them, but from Farak through the 911 call and different identifications and no issue of cross-racial identifications, and this Springfield police officer who allegedly stole the money, and that ultimately you look at this case, and you've got DNA in the van, and you've got the defendant saying, "Oh, my brother had nothing to do with it," and really, the only shot here is to be able to raise questions about the DNA. Because if you don't raise questions about the DNA, how are you going to deal with substantial likelihood? And that's what makes the booking video more important.
I would agree with that, and I
So,
would
I mean, I'm
also,
just trying to reframe your argument. Is that
I
right?
appreciate that.
The DNA is incredibly important here, and it ties into everything. Ties into not calling a transfer stain expert, ties into not calling a DNA expert.
Right, because the defendant's DNA is not at the crime scene at all. The only DNA is the victim's on his T-shirt, and I believe, I'm not sure, maybe in the van. But in the van, by the
That's the
way.
T-shirt that you're concerned about in the booking video?
Yes,
Oh, but wasn't that admitted in evidence, the T-shirt itself?
it was, but it was all cut up and all that. They had already worked on it. And that's why they asked the forensic person about the size of the stains, and she said, oh, they were about, she cut 3 inches, but the stains were about 1/4 of an
Did
inch.
she have a photograph of it before she cut it up?
I don't have that.
Do you know if they took any pictures of it at all?
I'm sure they did.
Did they take booking photographs of him?
Well, yes, they took one of them in a Johnny,
Okay, that's there, you got my question, right?
yeah. So, and that was after he was already booked.
Right.
They took his T-shirt off. So, one other thing regarding the van blood or stain is one of the 2 officers, Trujillo, was asked, did you see any stains or blood in the van because you went in the van to look for things? And he said, I didn't see any. I didn't see any. So that's a second issue with the, how the stains may have gotten to places.
And then there was a stain in some part of the van.
Yeah, there were 1 or 2. There was one, I think one on the steering wheel and one on the a door handle.
And again, that was by a forensic examiner looking at it and looking for stains.
Right, absolutely. By the way, and I'll finish this, if it's all right, about the booking video with Commonwealth v. Heath, which I know you're all familiar with, and I believe that's right on point. It's a material piece of evidence, which I'm going to suggest contained exculpatory evidence, a white T-shirt without blood, and we have 2 police officers testifying they didn't see any blood. There's some evidence that the officers weren't wearing gloves, so that's a possibility for the transfer, and something about a chipped tooth or a broken tooth. So I think the initial showing is
Wait,
reasonable.
what does a chipped tooth have to do with it? Because,
None of the witnesses claim they saw his tooth, so it goes to the identification issue.
but didn't he still have a chipped tooth later? Couldn't there have been some sort of stipulation that the defendant had a chipped tooth?
You can always have a stipulation, but none of the
I mean, that didn't go
Witnesses.
away, right? The chipped tooth, if he had a chipped tooth, that didn't go away.
Well, the trial took place, you don't know when it happened. I'm saying on the day of the event, he definitely had a chipped tooth.
Wouldn't the booking photo show his chipped tooth?
Well, if we had the video, maybe.
No, the booking photo.
No, it doesn't show it. They didn't, they show him in a Johnny with the booking photo was him in the Johnny with his mouth closed. So he's not smiling. He wasn't very happy.
I imagine.
So Heath, I think, again, brings us to that burden because of it's a reasonable possibility the testimony would have conflicted with Jennifer Presick.
Can you get into the?
And it's not a fertile imagination type of situation.
Can you move to the Bowden third-party culprit police chatter?
Oh, yeah, that's thank you. That is the dispatch tape.
Right.
And that is really involving third-party culprit evidence. Because what you have here is something that's not going to confuse the jury. It's not prejudicial. the very, very first descriptions of the suspects and the color of the vehicle are in the dispatch tape. And I'm going to tell you, if you look at RA...
Can you help me out? Did the lawyer try to introduce it as both under Silva Santiago, as both third-party culprit and Bowden?
Yes,
Or did he focus on one rather than the other?
I think probably more Silva Santiago than Bowden, but maybe both. But he didn't have a chance because the judge would not allow it in. And in fact, the judge allowed a little of it in, but for the prosecution, not for the defense. And I'm going to I know you all read everything, but I'm going to stress, look at the exhibit RA-105. That is the original dispatch tape transcription, and it has the description. It's extremely exculpatory. It has, and it represents the third-party culprit evidence. You'll see the van was tan. That's the original description. The van was silver or maybe gray, depending on...
Well, that's not as important, since they ultimately find there's only one letter off from the description from the neighbors. Isn't the more important point from the police chatter that it's significantly inconsistent with the appearance of the defendant? I mean, the defendant's 6 foot something,
Yep.
and the identification's 5'7" or 5'8". They didn't have the wrong van. It was one license plate number off.
Right, but listen, that's true. And that's an issue, another issue, but the original description of the suspects were thin. Both of them were thin. They were between 5'6" and 5'7". When we know, again, as you pointed out, but it's under RA 109, the defendant's over 6 feet, 240 pounds. And all this is the original information, 5'6", 5'7", thin. It is extremely important. In fact, I would say the Mana case, which I think Judge Budgie wrote that opinion, Mana, it shows that it was an anonymous 911 call that contained both sufficient particularity in its description of the defendant's vehicle, which was reported as tan, and the descriptions of the suspects, black males, thin, 5'6", 5'7", 5'8", both of them possessing masks, armed with handguns, even the clothing described. So if you look at 105, it's all in there, and it was sufficiently reliable because these are the caller's first-hand observations of what they reported.
Do we know who the source of the chatter was?
Well, that's why the judge kept it out. Judge claimed it was hearsay, but we have the names in that RA 105 of who was working dispatch, but they say we don't know who was calling in.
But that goes back to the question you may not have answered. I don't think you answered Justice Gaziano's question.
I'm sorry.
About if we can go back.
Sure.
About at trial, did the defense attorney seek to put the evidence in as Bowden for its truth, as hearsay that should be admissible under Bowden, or as impugning the integrity of the investigation, and it should have come in regardless of its truth? Or did the defense attorney not differentiate between the two?
There were a couple of discussions, and I would say sometimes there was it wasn't characterized. And once he said, but Judge, it's not for the truth of the matter. So he used both. It was said both.
I'm just trying to figure out whether we're at a substantial likelihood or not as it relates to the two aspects of Bowden. That's why.
Right. I think he would have used it as Bowden, obviously, if it was allowed in, but again, it wasn't. And clearly, it's third party. There's evidence that a third party committed the crime again, and they charged the defendant. And it has probative value. Evidence that's relevant.
Help me here to understand. there would be a 911 tape. Was that in evidence, or do we have that?
I'm calling this dispatch 911 because that's what they used when Sarah LaPalme testified. They used the 911 tape when she called in.
Okay, so what exhibit is that? Is that 105? Huh?
What exhibit is Sarah LaPalme? It's in the
No,
transcript.
no, what exhibit is the 911 tape?
I say it's part of RA 105. That what they call the chatter. I don't think it would. I
I mean,
think Sarah-
the chatter is a particularly unhelpful characterization, so.
Yeah, I'm not calling
I
it that.
can't, I know he is, and I know why he is, but do we have, I mean, I don't know whether or not the so-called dispatch tape includes telephone calls in reporting eyewitnesses saying this is what we see, or whether it's police officers doing a be on the lookout for a person. I don't know what chatter means.
No, I don't either.
What's
I don't
on
think
that?
it's. I think it's.
What do we
their phone
have?
call. I think they're calls coming into dispatch.
But there's more than that. There's two police officers talking about the initial description, too.
Also on that.
You're referring to, this is basically the turret tape.
Yes.
Okay.
Can I ask you, did it go before the jury that witnesses described the assailant as a short person, or
No.
I guess 5'7"?
No.
What are the roommate and what are the college students, how do they describe?
Well, only two of the college students testified out of the three.
Okay, but can you-
And the college students said that's him. It was like 6'1", 6'2".
Okay,
They didn't change their.
and what about the roommate? Did she say how tall?
Which one?
The person that lived with her?
Oh, Sarah?
Yeah,
Yeah,
what do-
Sarah said over 6 feet.
Okay, so all the live witnesses testified over 6 feet.
Correct.
And we have a turret tape where someone says 5'7", et cetera.
More than one.
More than one
You'll see
person
it, yeah,
said.
if you read 105.
Okay,
Well, I think-
and we don't know who those people were that said 5'7"?
I guess not. There was no follow-up. Again,
And
and
the judge said this wasn't Bowden because the second prong of Bowden wasn't proven, that being that there was an inadequate investigation of the description of the person.
right. So I see my time is up. I want to thank you all and just let you know I had some other issues, and you can read the brief on those. Thank you very much.
Okay, thank you. Mr. O'Sullivan,
Good morning, Mr. Chief
can
Justice.
you begin with the chatter, so-called chatter, as to what exactly is on that tape that the jury did not hear?
Certainly, Your Honor. It appears that what's on that tape, and I believe, to answer your question, there was a CD that had a 911 recording of Ms. LaPalme, and also conversations between police officers and dispatchers that had first responded to the scene. And I believe the entirety, both the 911 recording and the chatter was, I believe it was Exhibit G for identification. The 911 tape itself came in, it should have been the last Commonwealth exhibit because the Commonwealth only admitted the 911, and we had to go back and separate that from the disc that included everything. So I don't.
So is RA 105 in our appellate record Exhibit G for ID?
I don't know. I believe that was maybe the transcript of the chatter that the defendant maybe had transcribed. I accept the defendant's representation that it's the same disc, but
But do we have Exhibit G for ID?
it was in the trial. I don't know if the trial exhibits are transmitted here. But I believe it was Exhibit G for ID that had everything. But the essential contents were, again, communications between officers and I think some dispatchers that had arrived in the immediate aftermath of the killing.
But I gather it's a be on the lookout information.
Yes.
When you say chatter, I assume it's not, I mean, it's people saying police be on the lookout for a person matching this description.
Yeah, initially. But then I believe it was changed when they had received more information. And in regards to the judge's discretion in excluding that, again, even though, well, at trial, defense counsel never articulated a third-party culprit. The Commonwealth has him saying that he wanted to show that investigators, quote, jumped to conclusions quickly, close quote, and demonstrated, quote, confusion. The Commonwealth interprets that as, I guess, a Bowdoin-type argument.
Right.
However, as you know, Bowdoin's not constitutional. We're looking at that for whether the judge abused his discretion in the lower court. And even though hearsay sometimes is admitted under Bowdoin, the risk of unfair prejudice still has to not outweigh the probative value.
But, I think maybe the argument is, what else is there? What's really, I think, going on in the defendant's brief, although it doesn't say it, is, look, you got the defendant's DNA on the T-shirt. You got the defendant's DNA in the van. You've got witnesses seeing people running from the apartment to a van that matches, except the G looks like a 6 in the way it's written down. You got the defendant's first words saying, "Oh, my brother had nothing to do with it." All the defendant has in response to that is a combination of Bowdoin combined with suggesting that the DNA got there through the police. That's all they got in the face of those overwhelming facts, and they weren't able to pursue the police chatter with IDs that didn't match the defendant. I think that's what the argument is.
And I think the reason they weren't able to pursue it was because that even though hearsay is allowed under Bowdoin, it still needs to be probative. It still can't be prejudicial. I think the judge can still weigh the fact that it is unsubstantiated hearsay. We don't know who the speakers were in weighing the reliability of this evidence and its probative value. And he found that essentially it had no value. And furthermore, the Bowdoin evidence is admitted if the defendant can show that it was a track the police did not follow. But in this case, if we're going to look at whether the police followed the track of a physical description of the perpetrator, they most certainly followed that track. They interviewed every witness that got a potential glimpse at this guy, and every description of the defendant or of the perpetrator, whichever way you want to put it, was largely consistent as someone not being 5'7", but someone who's being 6 foot or taller, slender, African-American or black male, wearing the black hoodie, potentially masked. And that was the description that was consistent amongst all the witnesses that the police, and I would suggest diligently pursued. So for the defendant to then, put this unsubstantiated hearsay evidence from a source, whose authenticity we can't verify, the defendant can't verify. There's no further evidence from the defendant as anyone 5'7" that could have been involved in this, or any other descriptions from any other witnesses about anyone 5'7". I think the judge was within his discretion to exclude that testimony as confusing, waste of time, and lacking no probative value.
What about the defendant's argument? I know that he didn't get to it, but ineffective assistance of counsel of having a theory of the defense that the defendant, his own client, was a drug dealer. Couldn't the defendant have put in enough evidence to suggest that he was referring to his brother as being involved with the marijuana without painting his own client as a drug dealer?
Well, Your Honor, I don't believe the trial defense counsel painted an overly, prejudicial picture of his client based on the transcript. Additionally, as the trial judge noted in the motion for new trial opinion, a suggestion of marijuana distribution in light of the very serious allegations that the defendant was put in front of the jury on likely wouldn't have had that adverse effect on this jury. And the strategy to essentially, concede guilt on a much less serious crime was strategic, and I would suggest in no way manifestly unreasonable. That admission of consciousness of guilt was extremely damning to the defendant in the
When you
Commonwealth's
say that,
opinion.
you mean saying that my brother had nothing to do with it, and the drug dealing was the only way to deflect that comment?
And specifically, he's-
I'm just asking, that's a question.
yes, and specifically, what was said was, my brother had nothing to do with what happened earlier. And so the defendant had to put forth something that happened earlier to explain that. And what he put forward was a transaction involving drugs, a drug distribution. And given the severity of that admission, the harm that did to the defendant's case, I don't think that was manifestly unreasonable. Other ineffective assistance counsel issues that he raises, the failure to raise the issue regarding Sonia Farrak. Again, the defendant was arguing he wanted the jury to credit this drug evidence. That would have undermined the legitimacy of the substances, I think would have hurt his defense. He was also not convicted of any drug offenses. It's not clear what harm was there. And the other ineffective assistance claims he raised, lack of use of a DNA witness. There were no affidavits from any defense experts showing what their testimony would have been. And the cross-examination of Mr. Charlie Brown on his ability to see the defendant's hands was a failure to impeach, again, largely strategic in nature. And Mr. Brown's prior grand jury testimony also was that he could not see the hands of the shorter perpetrator. He was pretty consistent throughout that he could see the hands of the taller perpetrator who was later identified as the defendant. So
On the motion for new trial, was there an affidavit from Dr. Bernstein as far as the blood splatter?
I can't recall any affidavit from Dr. Bernstein, Your Honor. Maybe, perhaps I missed it.
I don't know.
But actually, and if I could circle back around to the blood splatter, some factual questions that might be, that the court had for defense counsel, which might be helpful. I think I have a few of the answers. Those blood splatters were testified by the criminalist. They were, there's a couple blood splatters, approximately 1/4 of an inch in size, so very small. She testified they were faint, they were faded. I would suggest they clearly would not have been shown on the grainy police booking footage. They were on the lower front of that shirt. It was a baggy, low-hanging shirt, a 5XL shirt. That shirt was admitted. It was not entirely cut up. The exhibits were transmitted. You can certainly take a look at it. Some of the portions where the red-brown stains were found were cut out. Pictures were taken of those. They should be exhibits 63 to 66, so the court can see the faint nature of them and how tiny they were. And as far as the responding officers, the officers that the defendant claims could have potentially contaminated the scene, Officers Podgorski and Cerullo were the ones who apprehended the defendant. They had backup from Officers Rivera and Rodriguez. There was no evidence to suggest, first of all 4 of these officers appear to have been patrol officers, not involved with the detective work on the homicide. There's no evidence that Officers Rivera and Rodriguez were ever at the scene. Officers Podgorski and Cerullo did testify that they went to the scene of the homicide, but the prosecutor at trial was very careful and diligently went through what they did when they arrived there. And it was very clear that they went to the scene, spoke with other officers merely to receive information, but that they never went inside the building or near that victim.
Do we have the videotape that was provided to defense attorney counsel that didn't have the defendant on it? Was that part of our record, or is it part of our record? Because that would show us whether or not this is like, high definition booking photo or
Certainly.
grainy.
I don't know if, so there was Exhibit 21 at the trial was the defendant being led through a carport in the booking area. And I believe it's the same video that shows, or the same vantage point, the same camera that would have showed the booking process as well.
So the error was that, in discovery, was that this was prior to, they gave the defense attorney the booking video that was prior to the defendant's appearance, correct?
Yes, and again, it still showed the defendant. What had happened was what had been produced was a video that was, I think it was 2 or 3 hours worth of footage.
I guess, was that part of a record for the motion to dismiss, or was it an identification, marked for identification at trial?
I can't recall if the entirety of the video was marked for identification at trial. I think it might have been at some point, but I can't recall the exhibit number that it would have gone in as. But part of it was that Exhibit 21, because what was produced ultimately included the defendant being walked through the carport, which the Commonwealth introduced, and the other footage of essentially nothing, just officers in the booking desk sweeping up. Another person gets discharged from booking that can be seen on it, but the video ends, I think 20 minutes prior to when the defendant was actually booked, which was an error on the police department and the Commonwealth in not producing that. But Your Honor can certainly see on Exhibit 21, because it's that same vantage point, the quality of the camera. And you can see that also, in my opinion, the colors are changing, it's grainy. It's a very low quality video. And you can see the defendant walk through from the carport as well. And you can see not a great level of detail on his shirt. He also had gray stains, I believe, on the shirt that were, the criminalist, I think, tested for negative tests for GSR. Those can't be seen on the T-shirt either when the defendants walked in from the carport. So any suggestion that the loss of the defendant's booking would have led to credible evidence that would have been part of the jury's consideration, I think, is highly speculative.
Well, be that as it may, the DNA of the victim is on the T-shirt,
Yes.
and no video is going to change that.
Correct, and also, it doesn't solve the defendant's DNA problem in regards to the van, because the DNA of the victim, the blood of the victim, is found on the passenger side of the van. The defendant's found driving that van. It's the same van that matches the description of what the perpetrators fled in. It's the same van that matches the description that was seen outside the victim's home just prior to the murder. In addition, the defendant's fingerprint is also found on the same side, front passenger side of the van where the victim's blood was found. And so even if the defendant were to establish that there was some transfer of blood from the scene to the defendant's booking 5 hours after the fact, which I would suggest is highly speculative, it does nothing to change the fact that the victim's DNA blood was found in that van he was driving. In regards to the Heath case, which the defendant relies heavily on, the Commonwealth would just draw to the court's attention, as I'm sure you're aware, that that case, the crime happened in the booking area, and that's a very important distinction than the booking video that would have been produced in this case. The defendant's chipped tooth as well would have been cumulative evidence, because the defendant at trial was able to present evidence of the defendant's chipped tooth in the form of a video interview still photograph, and then a portion of that video interview with the sound muted, about 1 minute of that, to show his chipped tooth. The defendant, I think, invoked his right to counsel or silence. Obviously, that was never before the jury, so they weren't able to hear what was said, but that video did exist showing the defendant's chipped tooth, and he was able to show the defendant's chipped tooth in appearance on that night of the homicide. So any further evidence of that in the booking video would have been cumulative, and I don't think would have been seriously a part of the jury's deliberations. There are some other claims of the defendant in regard to the show-up identification as well. The Commonwealth would like to briefly cover that. The show-up was in the immediate aftermath of the crime, within 2 to 3 hours after it occurred, which this court has suggested as a very compelling reason to conduct a show-up procedure, especially during this type of a crime. So there are clearly exigent circumstances that existed. The witnesses were advised per Silva Santiago. They were separated. They viewed the suspects individually. There was never a cross-racial identification issue raised at trial. The case was pre-Bastaldo, so even had it been raised, it would have been in the judge's discretion. I don't believe the defendant can show that he would have benefited from asking for one on this record. And because the identifications followed the proper protocols, the Commonwealth would suggest that they were not flawed. They did not contribute to a substantial likelihood of miscarriage of justice. And finally, just under the general 33E review, the van that the defendant was later found driving was identified on the victim's street just prior to the homicide with a plate number. The defendant himself was ID'd by 2 witnesses as being in a yard next to the victim's home just after leaving that van and prior to the homicide, where he admitted he was, quote, hiding out. The man that entered the home largely matched the description of the defendant. The defendant was identified by a witness who saw him in the home and then fleeing from the home as matching the physical makeup of the perpetrator. The defendant masked, fired a round into the vicinity of a 3-year-old girl in an attempt to elicit fear. He was seen dragging the victim into the basement. Miss LaPalme and Miss Brown, the defendant was then seen fleeing by Mr. Brown with the victim's safe or lockbox into that same van, matching that same description that was seen earlier. The victim was shot 2 times. She appeared to suffer. There was evidence that she was conscious at the time when she was discovered shortly after the shooting. And when the defendant was apprehended, he made the very incriminating statement that my brother had nothing to do with this earlier. He was found with an amount of money that was believed to be consistent with the amount the victim had in that very safe. And then the important DNA evidence that the victim's blood was found both on the defendant's shirt and on the passenger side of that van where the defendant's print was found. The problem the defendant had with this case, the Commonwealth would suggest, was not the assistance of counsel or any errors, but the strength of the Commonwealth's case. I see I'm out of time. Thank you. I'd ask you for the judgments. Thank you.
All right, thank you. We'll take a morning break. Thank you.